May it please the court, Assistant United States Attorney Keapuni Akina. My name is Harlan Kimura, and I represent Mr. Brian Melvin Brandenburg. May I reserve 3 minutes for rebuttal? The jury was denied the opportunity to determine whether the emails that Mr. Brandenburg sent were true threats or protected by the First Amendment, because the diminished capacity instruction was not given. If that instruction was given, the jury would have been able to look at and consider the several pieces of evidence that could be an indication of Mr. Brandenburg's diminished capacity. He was taking marijuana and magic mushrooms during the time he sent the emails. He was emotionally distraught. He was going through a divorce. He was supposedly going to lose everything. Also, another very, very important point about why Mr. Brandenburg could have not been totally have his wits about him was that when the federal FBI agent interviewed him on May 6th, he told the FBI agent, "My family, unbeknownst to me and without my consent, had brain surgery on me and removed my heart." Now, if that was true, I don't think the interview would have been taking place. Mr. Brandenburg would not have been there. That in itself should at least lend the district court to think there must be something wrong with Mr. Brandenburg. Now, whether it is the emotional distress or was it the marijuana or the magic mushrooms, there was enough evidence at least to have the diminished capacity instruction given. And backing up, as far as the FBI interview, that was evidence that was submitted by the government, not by Mr. Brandenburg. The district court was asked by defense counsel at trial, let the jury decide that question. But the district court...
Didn't your client say that he could function and do all kinds of complicated work while he was intoxicated?
That's correct. He did say that, and he did say that he was writing a 200-page book, and he could also program sort of a lot of complex things. But all that goes to show is that his evidence and the testimony could be weak, inconsistent, or may even have doubtful credibility. But that does not eliminate the evidence to warrant a diminished capacity instruction. The other thing is that Mr. Brandenburg, as you may be able to gather from the excerpts of record, is that he is a very intelligent, self-made individual. But at the same time, he does have very strong opinions and views in terms of what his worth and his capabilities are, which may have been part of the reason why when he testifies, he says, yes, I was taking magic mushrooms, my capacity was diminished because what I thought and what I did was diminished, and that's in the record.
Can I ask you to move to the obstruction of justice enhancement? So I have a question about exactly what your argument is on this. Are you saying that the court never made a finding of willfully lying on the stand, or that somehow the finding that was made was flawed?
Our position is that initially the district court could not find willful. The government convinced the district court that because the jury found willful, you find willful to the district court. And the district court did say that essentially it was the jury who found willful, so I found willful.
So what's a little bit confusing here is that what the jury found was that he willfully threatened, but what the court needed to find was that he willfully lied on the stand, right?
Yes. And the district court didn't make that independent finding that he willfully lied on the stand.
And why, okay, but you think that the judge said, I find willfulness for perjury?
I don't recall the district court ever saying the word perjury.
Okay, but the judge knew that one of the findings that needed to be made to impose the enhancement was willfulness.
Yes, it was willfulness, and that's what the district court found based upon what the jury's verdict was, as compared to the district court making an independent finding.
So I didn't see an argument really in your brief that the judge misunderstood what type of willfulness was at issue. I'm kind of asking you about this because I think the jury was asked a different question about willfulness than what the judge needed to find for the enhancement. But I don't think you argued the judge didn't even understand that the willfulness was willfulness about lying.
That is correct. Our only argument in the opening brief as well as the reply was related to the district court relying upon the district court's, the jury's verdict as compared to making an
And what case do you have that says that the judge, are you saying that it's not appropriate for the judge to even take into account what the jury found?
No, the district court can take into account what the jury found, but the district court would still have to make an independent finding that there was willful.
And what do you think independent means in that sentence?
The district court would have to state, okay, based upon the jury verdict as well as my review of the evidence as I sat through the trial, I make the independent finding that Mr. Brandenburg was willful. And that also relates to another point, which is a constitutional issue. The issue regarding willful relates to obstruction of justice as well as to acceptance of responsibility. Now, in this case, Mr. Brandenburg exercised his First Amendment right because the question was whether it was a true threat or was it his First Amendment right to send those emails. If you find that whenever a verdict is rendered against an individual, that it's a true threat as compared to a First Amendment right, when the First Amendment right is advanced, it creates a very chilling effect upon anyone ever wanting to go to trial. Because in his mind, Mr. Brandenburg believed that the emails that he was sending was based upon his First Amendment right and not a true threat. Now, it could very well be that it was because of his diminished capacity, because of how he views himself, or for other reasons. But the point is, it's a First Amendment right as compared to other kinds of situations.
I want to get back to this your answer to my question about independent. Are you saying that the problem, what do you think the judge did wrong here on this willfulness issue?
In regards to the willfulness, the judge relied upon the jury's verdict to determine willful, rather than stating, I looked at all the evidence, I looked at the jury verdict, I independently came to the conclusion that Mr. Brandenburg was willful, and therefore the three parts are met, and therefore the obstruction of justice enhancement would be applicable.
So it seems to me that your basic objection is that the judge didn't tie it together in a nice package at the end. My question is, the judge laid out the correct requirement, meaning an independent judicial finding, but why isn't the colloquy and the fact that the objection had focused on the jury verdict, and then, of course, that was discussion, why isn't the ultimate conclusion taken as a whole sufficient here?
Our position is that initially when the judge first came into the sentencing hearing, she did say that she had a question regarding willfulness. And it was the government who sort of convinced the judge that there was willful based upon the jury's verdict.
But the judge also said coming in, I need to find these three things, right?
That's correct, and that was correct. Those three items were the things that the sentencing court needed to find.
I also think, though, that at ER 21, I don't know if it was you or someone else, but whoever, Mr. Brandenburg's lawyer argued on this willfulness issue, the jury did not find that Mr. Brandenburg perjured himself. So the objection on willfulness to the judge was based on what the jury did, and that was the defense counsel saying that. So I'm wondering if whatever your issue about independent finding is was invited error.
Well, as far as the defense trial attorney, yes, there could have been the differentiation between whether there was perjury or whether there was a willful in regards to based upon the jury instruction.
I think, let's say we all agree with you that the judge was not bound by the jury verdict and needed to reach and make an independent finding apart from the jury, that there was the three elements, right, including willfulness. Part of the problem is the transcript shows that lawyers for both the government and the defendant argued only about what the jury found or didn't found, and no one said to the judge, it doesn't matter what the jury found because you need to look at the evidence independently and make your own finding. And even if the jury said it was willful, it doesn't matter, judge, you can make a different finding for the purpose of this enhancement. So I think the struggle is in the absence of anyone making that argument to the judge, now reviewing what happened below, even if we agree that the judge needed to make an independent, was that objection forfeited or waived, or are we on plain error review and we can't reverse on that ground?
Well, Your Honor, we would argue that that argument is not waived. Now, maybe the specific rationale or the argument as to why that obstruction of justice should or should not have been recognized, that may not have been clearly articulated at the sentencing level rather than in our briefs. As we all know, we have more time to think about it, and so we have more time to make additional arguments.
So if, let's say it wasn't waived, but it was not preserved in a way so that it's being argued for the first time on appeal, this lack of an independent finding, then we would be on plain error review, is that correct?
I would slightly disagree, Your Honor, because the point is that we did object to the obstruction of justice as to whether the reason or the rationale for that, the independent finding was not made by the district.
So you think the objection, even though you didn't maybe articulate it perfectly, was preserved so that we're on de novo review?
Yes, at the sentencing, it was preserved. It was better articulated in the brief.
In the briefs, just better, but it wasn't not at all below, is your argument?
Yes, Your Honor.
Your time is ticking by, and I wanted to know if we could shift then to the other enhancement that has to do with the disruption on the court staff. So I wanted to know if you can give us, in your best articulation, what would be the threshold for when the security staff would need to go beyond its normal duties so that you could impose the substantial disruption?
It would be the delivery of services or the function that would have to be substantially affected rather than behind the scenes, in this case, the court security personnel having to do additional security check and also further reviewing the security cameras. So our position is that for the District Court of Utah Family Court, their delivery of services and their function was to serve the individuals that are going through a divorce. And nothing changed according to the record as far as the delivery of services to those clients or those parties. And therefore, our argument was that there was no substantial disruption of governmental services or functions because the Utah Family Court operations were not affected. Now, the security personnel did have to do additional things, but that's what they're required to do. They're required to protect the court. Whatever risks or threats are made, their job is to protect the court.
So,
That kind of begs the question, I guess, because of course you need to protect the court. You now have these threats called in, or at least surfaced, not just at the court, but in other locations. So at what point does protecting the court go beyond what you might call the everyday duties? Because you're not normally reviewing all the security cameras, you're not making those judgments.
There are two parts to that, Your Honor. As far as the delivery of services or functions, that's what the public sees. The substantial part is related to, let's say, for instance, the security personnel. How much effort did they have to do to protect the courts?
And I've been looking at the case law about this enhancement as well as the related guideline about variances that is not an issue in this case, but also uses that phrase, governmental function. And it seems that there's an argument that it's about governmental function really has to be viewed at sort of an organizational level. I think that's your argument, that we're not looking at the discrete, part of the court being court security, but we're looking at the court function, and then that there's no evidence that that was disrupted.
Yes, because the district courts, family district courts, function was to serve the parties, and that was not affected. But yes, security personnel, they did do a lot of things. So yes, there was substantial, but it didn't affect the services or
The
function.
function of the court.
Yes, Your Honor.
Okay.
Your Honor, I do notice that I ran out
I'll
of time.
still give you 2 minutes for rebuttal. Let's hear from the government, though. Thank
Okay,
you.
thank you, Your Honor.
Good morning, Your Honors. Keopuni Akina on behalf of the United States. So I want to address the obstruction of justice argument first. And I agree with the points that Your Honors made just a few minutes ago. The district judge did come out and did know and state what the appropriate standard was. I don't think there's a question that in the district court's mind, the district court knew what had to be done. And there's specific language that's cited in the briefs about willfulness specifically and how that the judge couldn't reach that on their own, and specifically with reference to the jury. And I think the observation about how the genesis of this entire conversation at sentencing began with defense counsel there, referencing how the jury didn't find willfulness for the purposes of this.
Well, it was really the judge who came out the door saying, I'm having trouble finding willfulness.
Correct. I think prior to that, it's on page 21 of the excerpts of record, it begins with the judge asking trial counsel for the defendant, what are your objections? And that's how it starts off.
Right.
But I agree, the judge also initially, that's what the judge also said.
I mean, I will cut to the chase. What troubles me is that because of the Fifth Amendment privilege, right, that is partly why we require judges to make independent findings and to not be bound by how the jury verdict. Right? And then here, the whole colloquy during the sentencing hearing was about what the jury found. And it seems to me, then the judge says, okay, it was reasonable for the jury, a reasonable juror could find willfulness, therefore, I find willfulness. And I don't, under our case law, right, the judge wasn't actually not only was not bound by the jury verdict, but is required to make their own independent finding of willfulness regardless of what the jury found in order to protect the Fifth Amendment right. So I just don't see anything in the transcript where the judge, either the lawyers or the judge, acknowledge that it, in some sense, doesn't matter what the jury found. What matters is the judge's own view of the evidence.
Certainly. So I would agree that that specific, that standard wasn't articulated at the sentencing. That doesn't mean that the appropriate finding wasn't made. And after the district judge says, like, okay, for the reasons that the government made, I'm convinced, that's not where the conversation stops. And I think if that's where the conversation had stopped and the judge had completely hung her hat on the jury's verdict, that would be a problem. But that's not what happened, because the judge then continued and says, the court notes these things, and those are things that the district judge had observed at trial. Those things included the fact that the defendant took the stand, he testified to the reasons why he sent those threats. He didn't intend to threaten people, he didn't believe they'd be taken as a threat, and that he wanted to raise eyebrows. And that reference to wanting to raise eyebrows that the district court made, that's a reference to the defendant's testimony at trial. And if you look on page 107 of the excerpts of record, that's where it comes from. And the question prior to that, the defendant is being asked by his counsel, I believe it's a direct examination, what was your intent in all of this? And he explains his theory of defense, which is, I wanted to attract attention, I wanted to, I sent these emails, I wanted people to take notice of that to get attention to my story. And he says, I wanted to raise eyebrows. So it's within this context. That's what the district judge, well, she didn't explicitly say that, that's what it's referencing. When you're talking about a reference to what happened at trial. It's this reference to the defendant's theory at trial that was very clear throughout, from openings, his testimony, closings, even now on appeal. I did not intend to threaten. I sent these emails to get attention, just not that type of attention. And so for the judge to then recognize that, okay, the jury also rejected what you said at trial. And I'll note that here, falsity and materiality, the other two elements for perjury, that's not being challenged on appeal. And so taken in context, right, it may not have been packaged as perfectly as we would like, but all the elements are there, sufficient to sustain this enhancement. And that's what was talked about in one of the cases that the defendant cited, Monzon Valenzuela. And Judge McEwen, you may be familiar with it. I believe you're on that panel. But in that case, the obstruction enhancement was found not to be appropriate because the court only relied on the jury's verdict. But the court also explained in that case that we have accepted perfunctory findings as long as they are clearly supported by the record.
I've gone back and I've looked at the transcript, and the problem I see is you said the court noted that the defendant testified and that he wanted to quote unquote raise eyebrows, and then she says, but the jury found otherwise. So I think, so she was referencing his testimony that he didn't intend to threaten. Then she says the jury found otherwise, and I think the reasonable juror could conclude that each of these requirements were met, and therefore a rule. Right, so there's not, to me, there's nothing there where it does read to me, at least the best reading that I can think of is that the judge was basing the decision solely on the jury's view of the evidence.
Well, I would respectfully disagree. I know the judge, no disagreement that the judge said that, but it's taken within the greater context of the judge.
You pointed me to something which I don't think shows the independent finding. Is there anything else that you can show me?
Certainly. So I think that is evidence of an independent finding. I think that the case that defense cited, that Monzon Valenzuela case that talks about how perfunctory findings are sufficient as long as it's supported by the record, clearly supported, that when you look at the defendant's testimony, his admissions at trial that he admits that he that he used threatening language. He admits that he took extreme measures. He admitted that he sent these emails to express anger, right? And then there are inconsistencies in his own testimony. For example, I'll give one. He claims that this was for clickbait, but on cross-examination, when he's questioned about the emails and the subject lines, it's not clickbait. And then the greater weight of the trial evidence, 6 witnesses who received these emails, they all
I
testified.
guess I'm not arguing the judge couldn't find it. I'm just asking whether they did independently.
Yeah, I think,
What evidence in the sentencing transcript is there that the judge independently found that?
right, so unfortunately, those words are never uttered.
Okay.
Right, but I think taken in context, especially when the judge comes into that hearing knowing and saying, I have to make these findings sufficient for this enhancement, and then at the end of it, applying that enhancement, I think inherent in that is the judge exercising her discretion in that scenario and making that finding, even though the word isn't said.
Just because time is running, I did have some questions about the substantial disruption enhancement. So if I understand the record correctly, actually, the PSR did not apply that enhancement. So it was the government's objection,
Correct.
right, to apply it. And the PSR actually said, we don't think it applies in response to the objection because there was no disruption of a governmental function. And your argument was that the disruption to the security in and by itself qualifies as a disruption to government function. And you didn't rely on anything other than the disruption to the security at the courthouse. Is all that correct?
That's correct.
Okay. And then, as far as I can tell, in the universe of applicable case law, unless I'm missing something, because it's always hard to know you've exhausted, but I cannot find a case where there was application of this enhancement based solely on an enhanced security response, right? So as far as I can tell, no court has actually addressed whether this factual scenario in which there was a security response that was admittedly beyond the norm, right, but still a security response. So security saying there's a threat, we're going to look for it. But the actual service of the government institution that we're talking about, or the function here, the function of the court is not to provide court security, it's to function as a court, and court security supports that function. Do you know of any case in which a court has addressed whether on these facts that counts as substantial disruption to a government function?
Right, so not on these facts where you're talking specifically about court security, no. I'm
Well,
not-
I guess security of some other broader organization or institution or facility. So I found plenty of cases where that was among the facts, but not where a court squarely addressed the question of when that's the only type of disruption, whether that counts.
Well, I would direct the court to the Snipes case that we cited in our brief. It's out of the 11th Circuit. I would also look at the Dudley case that's cited by the defendant. The Snipes case, I'll start with that. That was an 875C case. So there were threats that were communicated through the internet that the defendant was going to shoot a member of the Florida National Guard while they were at drill. And in response to that, well, the factors that are discussed in that court decision, those are all, I think those are all reactive steps that were taken, security measures that were taken in this case. And I think importantly to your Honor's question, in that case, there was no, the drills that were threatened, those were not canceled. Those went on as planned. But what was focused on were the security measures that were taken in the interim. This took place over the course of 2 days. Our case, it's over 3 days. But 2 days, they added 30 additional National Guard members to checkpoints. That's something that they were already doing, but they just added more people to these checkpoints. There was a threat assessment meeting that was called, similar to this case. So there was a threat working group that was formulated. There was a little bit of a delay that they noted in entry times for National Guard members going through these checkpoints. But ultimately, the drills that they were going to, that went as planned. That was not disrupted. And then additionally to that, they noted that they pulled state law enforcement and diverted them as well from their duties to assist in these matters. In the Dudley case, that was a case where there was a fake anthrax letter that was mailed to a judge's chambers, and that was a very short time duration. I think within a day it was all resolved, but 2 staff were quarantined, 2 judges were sent home for a few hours while this was resolved. There were law enforcement who were diverted from their regular duties, from their other duties, to provide security for those judges during this time period. And I guess in that case, it's not a perfect example because half of the floor for that courthouse, that was shut down during this
So
duration.
that would,
Difficulty, I mean, we've read all of these cases, there's some unpublished dispositions. There's a couple of the cases out of the other circuits. So when you even look at the plain language of the substantial disruption of a government function, here it seems to me that we don't have the shutdown, we don't have the redeployment of additional or people outside the courthouse. What is it, in your view, what facts would suggest that there was a substantial disruption? There obviously is some disruption, no doubt about it.
Certainly.
What makes it substantial in your view?
Certainly, I think the fact that they didn't just divert some available deputies in the courthouse to address the threats, they diverted all available deputies, right? I think that came out to a little bit, about half, maybe a little bit over than half of their 30-something deputies on staff. Their chief of security, Mr. Palmer, testified. In a nutshell, he said, I mean, he went through all the steps that they took, but he characterized it at the end, this was not business as normal. Breaks are all being canceled, people are being thrown into this. This is basically their sole focus.
right? I mean, the trouble I have is court security. I mean, any threat that is at all credible will result in we don't get threats every day, right? So I would say any threat would cause security to not conduct business as usual. And there's some suggestion, right, when I know we don't have the inherent in the offense language for this particular enhancement, but there does seem to be some problem with, inherent in the offense of, threatening, right? There's going to be a security response. And so it's a little bit troubling to say that, a security response in and by itself, but where there's no other impact on the organizational function is going to justify a significant enhancement. And I just don't see, a controlling authority. I think the Snipes case is unpublished. I don't see controlling authority or, even precedential persuasive authority that has addressed this issue of at what level or how should we consider government function for the purpose of this enhancement. So I guess to me, it seems like an open question of law that we have to define in the first place. And I guess as a matter of first principle, what would be the interpretive argument for saying it should include even just a security response, even just a security response that causes the officers to investigate the threat, essentially, in a way that's outside their everyday duties. That in and of itself should qualify as disruption to government function.
Right, certainly. So, the part of the problem, right, is there's no bright line rule, right? There's no rule that says X number of personnel need to be tasked with this thing. I would go back to the wording in the guidelines. There's an or there, functions or services, right? So it's not just services, public facing, and that typical thought, it's functions. What is our function? And if that function is being disrupted, the case law, they talk about diversion.
I guess at what level should we say the court function, or should we say the court security function?
Well, yeah, so again, going back, it's governmental, right? So it could mean a number of things, and unfortunately, it's not defined. From my viewpoint, I see that as it could mean a number of things. It could be the court's function, its ability to serve the public, but it could also be the function of the staff within the courthouse, right?
Yeah.
Because that affects things. If you're diverting all available personnel to address one threat, then you have no margin for anything else that could come up.
I would concede, that if it was just the internal court operations, but it was something beyond the security, I think that would be an easier case for you, right? So, but that's not this is just the security officers, correct?
Correct.
Okay.
And I would go, we sort of noted that in our brief, that there's no real definition, what is a substantial disruption? I couldn't find any within this circuit, at least. And the cases that I cite from outside of the circuit, there seemed to be this notion that, well, because it's undefined, there should be some deference that's given to the district judge at sentencing. And looking here, where the standard at the very highest should be abuse of discretion, I think there needs to be some deference
I agree
given
with you
to
on the
finding.
magnitude issue, because that's been something that a lot of courts have struggled with is the magnitude of disruption enough? But that hasn't, as far as I can tell, that's no court has really wrestled with what has to be impacted, right? And that's there because most of the cases, if not all of them, involve something besides the security response. So it just hasn't, as far as the question hasn't been forced essentially by the facts as they are in this case. And then we have the PSR saying, we don't think this is enough, and you're objecting. And I think that puts the legal question of what counts as government function.
I agree with that. I agree that, yeah, there's no clear controlling case law on
Can
this.
I ask you whether you think, if we were try to answer this question, whether it matters that this crime, the underlying crime for which the sentence was imposed, doesn't have a government element? So like, this crime could be violated just by threatening your neighbor. It happens that he threatened the government, and so then we have possibly government disruption, but it comes in the sentencing and not in the crime itself. Like, would it be a different kind of application of the enhancement if the crime was threatening a judge?
I mean, I think it would certainly, it would come out more at trial, right? Because that would be a part of the element of the crime. I don't know that it affects the applicability of the enhancement when it comes time for sentencing, though, because at the end of the day, you're still looking at who was actually affected by the defendant's actions.
If I recall correctly, it could also apply to business.
It could, yes.
So it would have to be just substantial disruption of the business function.
Right, I think the wording is public, governmental, or business.
Or business.
Functions or
So
services.
here, the combination of whether it's Singleton and all these other cases say a couple of things that you might divine. One, there needs to be something that's quantifiable. And in doing that, they talk about what's the time and duration, were any additional funds expended, what was the impact in the organization. So those are some of the, I guess, factors. And here, as I understand it, the key factors would be that they really had to deploy everybody, sort of all hands on deck, to trying to make the protection comprehensive, correct?
I would agree with that.
And so in that regard, there definitely was a disruption, but was it substantial in the sense that that's what all those people out there are supposed to be doing for all of us, whether it's the spectators or the judges, is making sure that the courthouse is safe. So I'm wondering, do you have any views on when you get above the threshold of substantial?
Trying to define what substantial means, I don't think I have a bright line suggestion, unfortunately, for the panel. I think it's one of those things that's going to be case by case. You know it when you see it, and if it's not, it's not. The other thing I'll add, you did mention one of the other factors, time and duration. This one was 3 days. The cases that are cited, are similar in length or shorter, 2 days to hours. So I think that would weigh in favor of the disruption and just the duration that this went on for. And Judge Song, to respond to what you're asking earlier, I mean, the counter to there no being any precedential case that guides us here is that there's also no case that says it can't be
I would say it
governmental
seems to me to be an open question, right? It seems to me you could have disruption, it could be a substantial disruption, but it may or may not be to a government function in this case, right? Because the debate really, as far as I understand it, between you and opposing counsel is whether the court security response, that seems as a factual matter undisputed that was a large, response, unusual response. But the question is whether cutting off court security from the overall entity of the court, whether we should look at it whether the government function should be defined as the security or as the court as a whole. I guess to me, that's really the legal question that I'm struggling with. And as far as I can tell, there's no court case that addresses that says either it is or it is not.
Correct.
Okay.
Do you think we're on plain error review for this issue?
I do, only because the argument raised on appeal is different. The argument raised here is that it wasn't a substantial disruption. I know here during arguments, I think counsel reverted back to what was argued at sentencing, which is that it has to deal with something that's public facing. That's what was argued, that for this to even qualify, the function or service has to be public facing. Right? That wasn't, on my reading, I didn't see that raised in this appeal, which is why we argued that it should be plain error here.
Because part of the problem I have is because it was really the government's objection to get the enhancement applied in the first place. And so all the colloquy with the judge was really about the government's arguments for why it should apply. And then the judge says, okay. And, the defense counsel says, well, I still disagree that it should apply. I mean, it's hard for me to find, fault, with exactly what defense counsel was arguing below when it was really most of the argument was about the government trying to say this should count. Does that make sense?
I understand Your Honor's point.
When we're talking about preservation of an argument below, and we're supposed to view preservation liberally. It's not supposed to be this overly harsh, nitpicky standard. And it seems to me that it was really the government who was saying the whole time, please do apply this enhancement. We're objecting to the absence of this enhancement.
I think that's a fair point, Your Honor. And even, I think as we noted in our brief, even under abuse of discretion, under either standard, whichever is applied, I think you come out with the same conclusion here, especially in light of the fact that there is a lack of controlling precedent here. There has to be some deference given to the findings made by the district court. And here the district court did make findings about how this was a disruption, about how, the security, they're typically tasked with security at the front door and in courtrooms, and the judge said, but this was totally different, a totally different requirement.
I could defer if I agreed legally, right, that government function includes, should be viewed at the more discrete level of court security. And honestly, I just don't know whether that's the proper interpretation of the enhancement at this point as a matter of law.
Understood, Your Honor. I would just know that distinction is not made in the sentencing guidelines. It's broad, and I think it's broad for a reason, so that the trial judges can apply it to certain sets of circumstances.
So I'll give extra time for rebuttal, but I have one other question that's on a different topic. So your opposing counsel started on this diminished capacity thing by saying something that I admit I don't quite remember about this surgery about the heart or something. Do you have a response to that?
A couple of responses. One, that evidence was put forward before the jury. I think opposing counsel started off by saying that there is certain evidence that wasn't provided to the jury, and going through the transcripts, that's not the case. In fact, the trial judge gave the defendant 2 chances to lay a foundation for this instruction to be established. One outside the presence of the jury, and then a second time at trial. And there was no limitation that was put on what the defendant could or could not testify about. And on top of that, this was put in front of the jury.
I understood your argument in your brief to be there was no evidence of diminished capacity, so there didn't need to be this instruction. But this weird thing about I'm dead or something, it does sort of sound like evidence of diminished capacity.
I didn't take it that way, and that's certainly not what was argued at the trial level, that, during those 2 opportunities, especially the one outside the presence of the jury, that was not raised at any point, as a basis for the diminished capacity instruction. And even, I understand that it came out and that it was evidence generally at trial, but going back to the case law, there has to be more than that. There has to be a link between the condition and someone's ability to formulate the requisite mens rea. And that link was also lacking at trial. There's nothing connecting anything, be it the defendant's use of marijuana and mushrooms, or this condition that may or may not have happened, but he talks about it in his debrief with the FBI. There's still no link connecting that.
I guess, sorry, if I understood it right, though, it's not that he really had no heart, and so that was the purpose, that was the cause of the diminished capacity. It's that him saying he has no heart is evidence of diminished capacity.
Again, I don't see it that way. I understand what Your Honor is
I mean, I think that's what,
getting at.
so is your argument that that theory was forfeited?
That theory wasn't raised. It wasn't argued at all at the trial level, so yes. But even if it was argued, I mean, still, you don't have that link. You know, there's the cases that are cited, there's someone who could have a mental illness. And if you don't have some testimony, it doesn't have to be an expert, just something that says, like, because I have this condition, I cannot formulate the requisite intent. You know, that's what's necessary, and that's what's lacking here.
Okay, thank you. We've gone way over, so thank you for your argument. Let's put 4 minutes on the clock for rebuttal, please.
There are 3 points I wanted to make. First of all, in regards to the finding of willfulness, it was the district court who said, as an afterthought about all this other evidence to buttress her finding that there was an obstruction based upon willfulness. But she didn't make an independent finding. Number two, in regards to the substantial disruption of governmental functions or services, the disruption, you would look at the target. Because in the United States versus Snipes case that the government referenced, the target was the National Guard. And the disruption was what the National Guard had to do in dealing with that threat. Now, the case before that, which is the Anwar case on page 11 of my reply brief, it sort of does say that the target is the disruption, whereas the substantial relates to what does the government have to do or security personnel have to do in order for it to be substantial. The third thing that I wanted to mention is that as far as the diminished capacity instruction, if the court were to find that there was sufficient evidence to at least warrant the giving of the diminished capacity instruction, that would result in a new trial, and that is the only option available. Because according to the court's Christian case, which was not overruled by the Bacon en banc in regards to the issue or the holding regarding.
So sorry, can I interrupt you though? So I understand that there was a discussion about whether the mushrooms, whether the drug use caused diminished capacity, and the court found there wasn't evidence that it affected the ability to form an intent. And then you came in this morning and started with this thing about a heart, and the government is saying no one ever argued that the statement about the heart showed diminished capacity. Do you think that anyone ever did argue that to the court?
I would agree with Mr. Aquina that the defense counsel did not argue that when there was the issue regarding the diminished capacity. However, the test is whether there was sufficient evidence to warrant the giving of the diminished capacity instruction, even though it may have been weak, contradictory, or of doubtful credibility. Now, the argument regarding whether he didn't have a heart and there was brain surgery, that was already evidence that was introduced. So the district court, it was incumbent also on the district court to take all of that evidence into account in addition to what the defense counsel argued. And even if you were to, let's say, exclude that part, there was sufficient evidence, although it may have been weak or inconsistent or of doubtful credibility, that there was a diminished capacity because Mr. Brandenburg did testify to that effect. The marijuana and the mushroom that he was taking did affect his thinking because there is a difference between what his thinking was and what he did, and he testified to that. Also, he did testify that, yes, he was spun out of control during the period of time this happened because there was also his divorce that was happening. So when you take all of those things together, there was some evidence that the diminished capacity instruction should have been given, and therefore a new trial is required. Are there any questions? If not, my time is over.
Thank you both sides for the helpful arguments. This case is submitted, and
you.
we are adjourned.